para 61 of my written submission. And is at page 568 of volume 5. The question formulated. Questions relating to the constitutional validity. Allows have?
Yes.
Questions relating to the constitutional validity of the different provisions of the Bombay Provincial Municipal Corporations Act as amended by Gujarat Act 8 of 1968 and number 5 of 1970 arise for determination in these appeals and the connected petitions. The Corporations Act was enacted by the Bombay Legislature in December 1949, so and so. That was. Now kindly come to paragraphs 44 to 47. Page 597. Mr. Tarpunde, on behalf of the petitioner company, has urged that under entry 49 of state list in the 7th schedule to the Constitution, the state legislature is empowered to enact a law relating to taxes on lands and buildings. It is submitted that the state legislature has no competence under the above entry to enact a law for levying tax in respect of the area occupied by the underground supply lines. The word land, according to the Learned Council, denotes the surface of the land and not the underground strata. We are unable to accede to the above submission. Entry 49 of List 2 contemplates a levy of tax on lands and buildings or both as units. Such tax is directly imposed on lands and buildings and bears a definite relation to it. Section 129 makes provision for the levy of property tax on buildings and lands. Section 139 merely specifies the persons who would be primarily responsible for the payment of that tax. The word land includes not only the face of the earth, but everything under or over it and has in its legal signification an indefinite extent upward and downward, giving rise to the maxim. I'm leaving that out. According to Broom's Legal Maxims, 10th edition, not only has land in its legal signification an indefinite extent upwards, but in law it extends also downwards. So that whatever is in a direct line between the surface and the center of the earth by the common line drawn belongs to the owner of the surface, and not merely the surface, but all the land down to the center of the earth and up to the heavens. And hence the word land, which is nomen generalissimum, includes not only the face of the earth, but everything under it or over it. Then they quote this, kindly have 46, which is also quoted, 47. Therefore, there cannot be a doubt that land in 49 would include the underground strata also. The other case which I wish.
What happens if the underground strata is also the subject matter of a specific entry?
That is the
there
content.
You were, I think, levying a conservancy tax, right?
Yes.
So on pipelines, etc.
But they were construing entry 49.
Entry 49.
Yes.
So what if a statute is relatable to both entry 49 as well as their tax on
I will
mineral
answer
rights?
this one more case, and then
all right,
I'll come
yes.
to that. And that is Western Coalfields versus Special Area Development Authority, Korba, 1982, 1 SCC 125. Western Coalfields versus SADA, Korba, which is volume 5, page 772. Yeah. 26 to 29 and 31. Apart from the fact that there is no data before us showing that the property tax constitutes an impediment in the achievement of goals of the Coal Mines Nationalization Act, this was a case where it's on the mineral-bearing land that's involving coal, under which special areas and special area development authorities are constituted, afford an effective answer to the Attorney General's contention. Entry 23 relates to regulation of mines and minerals, and entry 54 is then referred to. And after that reference, it is true that on account of the declaration contained in Section 2 of the MMDR Act 1957, the legislative field covered by entry 23 of list 2 will pass on to Parliament by virtue of entry 54. But in order to judge whether on that account the state legislature loses its competence to pass the Act of 1973, it is necessary to have regard to the object and purpose of that Act and to the relevant provisions thereof, under which special area development authorities are given the power to tax lands and buildings within their jurisdiction. We have set out the objects of the Act at the commencement of this judgment, one of which is to provide for the development and administration of the special areas through special area development authorities. Section 64 of the Act, which provides for the constitution of special areas, lays down by subsection 4 that notwithstanding anything contained in Madhya Pradesh Municipal Corporation Act 1956, the Madhya Pradesh Municipalities Act or the Madhya Pradesh Panchayat Act, the municipal corporation, municipal council, notified area, panchayat, as the case may be, shall in relation to the special area, and as from the date of the special area development authority undertakes the functions under clauses 5 or clause 6 of section 68, cease to exercise the powers and performance and functions and duties which the special area authority is competent to exercise and perform under Act of 1973.
Yes.
And then the last sentence, though therefore on account of the declaration, the legislative field covered by list 2 may pass on to the Parliament by virtue of entry 54, the competence of the state government to enact laws for municipal administration will remain unaffected by that declaration. Entry 5 then is referred to, and kindly have para 29, the decision of this court in Bajnath Kedia, on which learned Attorney General relies, is distinguishable. In that case, the Bihar government demanded red rent, royalty, and surface rent from the appellant contrary to the terms of his lease on the strength of amended Section 10 of the Bihar Land Reforms Act 1950 and the amended Rule 20 of the Bihar Rules. This court held that the pith and substance of the amended Section 2 fell within entry 23, although it incidentally touched land, and that therefore the amendment was subject to the overriding power of Parliament as declared in Section 15 of the Mines and Minerals Regulation Act. By the aforesaid declaration and the enactment of Section 15, the whole field relating to minor minerals had come within the jurisdiction of Parliament, and no scope was left for the enactment second proviso to Section 10 of the Bihar Land Reforms Act. Second sub-rule added to Section 29 was therefore 20 was held to be without jurisdiction. That declaration in Section 2 of the MMDR Act does not result in invalidation of every state legislation relating to mines and minerals, is demonstrated effectively in the decision of Haryana versus Chananmal. The state of Haryana legislature passed the Haryana Minerals Vesting of Rights Act 1973, under which 2 notifications were issued for acquisition of rights to saltpeter, a minor mineral, and for auctioning certain saltpeter bearing areas. it was held by the court that the Haryana Act was not in any way repugnant to the provisions of the Act of 1957 made by Parliament, and that the ownership rights could be validly acquired by the state government under the State Act. The decision of the Constitution bench and Ishwari Khetan is referred to, which can be. So then this taxing power was upheld with respect to the coal. So now let me respond, Malak, to.
In fact, para 28, that last sentence, the paramount purpose behind the declaration contained in section 2 of the Mines and Minerals Regulation and Development Act is not in any manner defeated by the legitimate exercise of the taxing power under section 69B of the Act of 1970.
So the first response, my lord, is that entry 49 list 2 is the exclusive entry of taxing power with respect to land and buildings. There is no other entry in any of the lists which operate in the same field of tax on lands and building as a unit. As an aggregate, it may come in entry 86 as an asset. Third, in particular, mining land would not be outside the fold of entry 49 list 2. The fourth is the framers of the Constitution, therefore, contemplated that the state legislature should have competence to impose tax on land and building of all kinds, notwithstanding the other regulatory entries. The fifth submission is
notwithstanding
any other regulatory entry in any list.
Yes.
And that is because the regulatory entries by themselves do not have a taxing. Do not have the field of taxation. The fifth is that as long as the measure of tax which has been adopted has close and proximate nexus with the land, keeping in mind its user, or non-user, the levy of tax by the states would be valid and competent. Sixth, my lords, In the cases before your lordships, the case of MADA, that is Jharkhand state, is squarely at the rate of not more than 1.50 rupee 1.50 per acre. And it applies across the board to all kinds of land. So in this case, there can be no dispute that the measure of tax is directly and intricately connected with the land.
Yes.
So it's not a case where mineral bearing land alone is being targeted. The next words, in other cases, the annual value does include the annual value of the mineral also, although it also applies across the board to other lands also.
In other cases,
Yes.
annual value
Of land.
Yes.
And they also apply across the board to all kinds of land. But in the case of mineral bearing land, the annual value is determined on the basis of the mineral value dispatched. The incidence of the tax is entirely on the land and the measure also has proximate nexus with the land from which the mineral has been extracted. In fact, until extraction, it lies embedded as part of the land. And hence it will fall exclusively under entry 49 list 2. Alternatively, if I'm assuming that if your lordships ultimately hold that in as much as in the latter category of cases, excluding Jharkhand, the annual value of minerals is a measure and the mineral value is also intricately connected with the mineral rights. And therefore, by virtue of entry 50, the Parliament has in the interest of mineral development a role to play by providing limitations and hence there is an intermix of entry 49 and 50 in that situation, it may be possible to take a view that with regard to such tax based on annual value of minerals, Parliament can by law impose limitation. And lastly, Milos, if I am right, and if Kesharam is right, that royalty is not tax.
1 second.
I'm sorry. If I'm right and Kesharam is right in saying that royalty is not tax, then I would submit that there is no provision at all in the MMDR Act 1957 which imposes specifically and expressly any limitation whatsoever on the state's legislative competence under entry 50, list 2. Stop. Therefore, all the laws impugned would be valid even if entry 49 and 50 are read together. That's my response if your lordship said. So if the intermix, if your lordship take that view, then
there would be, I'm just saying the limitation of my question. There may be some difficulty in accepting my line of questioning before the lunch for this reason that for us to, subject to hearing the other side,
Yes.
I'm just thinking aloud,
yes,
that for us to accept that proposition, which I was trying to put forth for your consideration, we will have to then say that the levy itself is under entry, the levy itself
it's not under
is
land.
not under land, but under, it's that it's a tax on mineral rights,
Yes.
or that it's a tax on land and on mineral rights.
Yes, or
It's sort of rag bag, as we said. Justice Venkatachala used the word rag bag legislation
Rag
in the
bag.
context of the Parliament's power.
That's right.
But if you are right that the mineral value is really a measure and not the taxing event, then the alternate point which you urge will not really arise then.
And if I may just add one more,
Isn't it? Otherwise,
if I may just add one more reason, Millers.
I mean, you brought a great deal of clarity to it because this was worrying me actually. But we'll hear the other side. Of course, we are open.
So just one more aspect I want to project, Millers. The fact that the tax is resulting in enhancement of price is wholly irrelevant, because every tax results in enhancement of price.
Always.
Which ultimately, so far as the companies which are questioning.
That's why in Jindal Stainless,
yes,
we overruled the earlier line of authority. We said tax is never a restraint on pay.
That's right.
That was the view of the majority.
So we have
everybody has to bear a tax.
We have just been, if I may just indicate in my written submission, after paragraph, after page 58, kindly just see the index. Kindly just see the index at page 4, part 2. So the basic principles I have mentioned a lot, and all the cases which I could.
Sorry, what were you referring to?
Page 4 of my written submission,
right.
Volume 1A. That is part 2, page 57 onwards till the end.
Yes.
There are 8 principles with regard to taxation, and I have enlisted all the relevant cases which your lordship may just take a note of. I'll not read all those cases. These are well known. As Mr. Salve said the other day, there's no controversy with it. It's an application of the principle which really causes the real rubbish. That is my humble submission. I'm extremely grateful for the time.
Thank you, Mr. Dwivedi. Sanskriti, you're not running away. Come, we are putting you in to give us a 5-minute exposition of your point of view. Just 5 minutes of your recap. Take your time, collect your thoughts. We never told you that we are going to hear you. Go slow, take your time.
Your Lordships, I am actually adopting Mr. Dwivedi's submission, whatever had to be argued, he has argued that, my lords.
Yes.
So far as royalty and tax, my lords, inherently there are different levies. Royalty, as your Lordships, as Mr. Dwivedi said, it is for parting with the privilege, my lords. Similarly, in cases of excise, when the state grants license for liquor, that is a similar levy, my lords, and there are constitution bench judgments which say that it is not covered under 366(28). It is not in the nature of tax, cess, duty, levy. That is because the state is parting with the privilege of undertaking this business of in the trade of liquor. So that is one thing. So structurally they are different. That is one thing. And merely to say that, merely to usurp the power of states under entry 50, MMDR Act is being invoked to say that royalty is tax, and therefore that field is occupied. My lords, therefore the levies are absolutely different. Section 9 in no way affects the competence of the state under entry 50 or entry 49, my lords. And as Mr. Dwivedi said, my lords, we are primarily on entry 49. We don't need to go to entry 50 because it's a tax on land and building, my lords. Before entry 14, my lords, in Government of India Act, my lords, it was tax on land, building, hearts, and windows. That was the entry, my lords. And there are several cases, my lords, whatever use the land may be, factories. Recently, tax on mobile towers has been upheld by your lordships under entry 49, my lords. So it could be factory. In Jagannath Baksh, my lords, the argument was it's an agricultural land. Agriculture is dealt with different entries. So you cannot tax. Your lordships of Constitution bench said, no, there is no reason why non-agricultural land can be taxed and why agricultural land cannot be taxed. So the use to which land is put is absolutely irrespective. It doesn't affect the competence of the state, my lords. It could be anything, my lords. It could be put to any use, my lords. And entry 50, my lords, I think that has been covered, my lords. I'm obliged, my lords.
Thank you. Good. Yes, Mr. Narendra Reddy.
Not appear for the state of Andhra Pradesh. But I'm appearing in items 901.60, 65, and 66. So 901.60, 65, and 66.
Yeah.
But I was going to start with saying, that my job was very difficult because I had to follow my senior friend, Mr. Dwivedi. Your Lordships made it more difficult by asking my younger friend, Sanskriti, also to just place some points before your Lordships. The difficulty, my lord, when doing a rear guard with the counsel like Mr. Dwivedi is, the battle hardly comes to us, but when it comes to us, my lord, we're left with no arms. All the arms are already used and extinguished. But I'll try to motor along, but I'll be very quick on the points that I only want to supplement. I'll not be repeating, my lord, what points were argued. If I may start, my lord, with Article 366(28), imposed taxation, my lord.
Yes.
Lord, 366 provides that in this constitution, my lord, unless the context otherwise requires, the following expression shall have the meanings. So taxation, my lord, for the purpose of the language used in the constitution will include an impost. Now this only means that entry 50, which enables, my lord, the state to tax, enables the state to have an impost also. It elasticizes, my lord, the constitutional expression. This cannot be used to say that some other expression used, some other enactment would have to be stretched to fit it into the concept of tax under the constitution. So this, my lord, is in favor of the state because it means that the state's power to tax would also include the state's power, my lord, to have an impost. If impost can be treated as something other than tax.
Does imposed have a meaning distinct from the word tax, or what is the meaning? What is meant by imposed actually?
Yes, my lord. In a different context it may, but
Is
as
it-
my
is-
friend Mr.
Does it
Dwivedi
really mean a compulsory exaction, or what is the meaning of an impost actually?
yes, but maybe flows from the expression imposition, which is, my lord, an exaction. If it is a compulsory exaction, if it does not have the characteristic, my lord, in this case, my lord, for the purpose of 366(28),
Context of imports and exports, it's got a special implication. US Constitution uses the word import separately. That's how it is. I'll try.
Yeah.
Yes, yes.
yeah. But for the purpose of 366(28), my lord, I completely rely on my senior friend Mr. Dwivedi's submission that if impost is read in the context it is placed. And because 366 itself specifies, my lord, that unless the context otherwise requires, it would be read in the same manner. But my respectful submission would be imposed for the purpose of 366(28) may not be very different. My lord, maybe in some other context it may mean differently, but your lordships, my lord, are not going to be troubled by that aspect in this matter. Because your lordships are now dealing whether section 9 would constitute an impost. But just to answer my lord's query, if the impost otherwise has all the characteristics of a tax, it will be a tax. If it has, my lord, certain characteristics which completely distinguish, my lord, the amounts do not go to the consolidated fund. It is not something, my lord, that is in the relation to a general, my lord, augmentation of revenue. If it has an element of quid pro quo, which may have certain characteristics of fee, then in such context, my lord, impost may have a separate significant meaning. But my lord, for the purpose of the constitutional provision 366(28), my lord, no citer a society, my lord, learned senior counsel argued, I'm just adopting it. It cannot have any, my lord, completely different meaning. My lord, something like royalty, which has no characteristics similar to that of a tax, cannot be brought within the fold of that. While 366(28) itself cannot be used to see if section 9 can be treated as tax, because 366(28) is only for the purposes of constitution. But just extending that logic, even then, on demurrer, that section 9 imposed cannot qualify as tax because it does not have any characteristics that are otherwise commonly attributed to tax. Yes. Lord, section 9 of the MMDR Act, my lord, is the section that is being referred for the purpose of, my lord, persuading your lordships to place a clog on the state's power either under article, my lord, entry 49 or entry 50 of list 2, section 9. If I may read 9, but after reading for your lordships entry 50 of list 2 once. But my effort would be to show to your lordships that 9 would not qualify to be a law for the purposes of the restriction, my lord, that entry 50 contemplates. My lord, entry 50 of the Constitution, if I may just read, your lordships have been taken through this many times. Taxes on mineral rights subject to any limitations imposed by Parliament by law relating to mineral development. My lord, the limitation would have to be on the state's power to tax.
Yes.
My lord, the limitation would have to be explicit and express because it is excluding otherwise a constitutional power granted to the state.
Yes.
So this power to impose limitation does not confer a separate authority on the central government to tax. My learned friend used the word it cannot usurp, but I am saying that there is no tax enabling authority power, my lord, under the Constitution. There is no taxing provision in list 1 in relation to mineral rights. The limitation power cannot therefore be read as a taxing power of the union, particularly when it is placed in list 2. It is a limitation on the state's power under list 2. It cannot be transported or telescoped to list 1 to exalt it, my lord, to the status of a taxing power given to the union. But section 9 of the MMDR Act but only continuing from the full force of my learned friend's submission, adopt it fully that royalty is not a tax. It is only a share. It does not have any characteristics of tax. 9(3), which was referred, my lord, for the purpose of inferring a limitation on state's power to tax in India Cements, is in fact, my lord, a limitation of the central government. It is not on the state government. albeit, my lord, in the context of royalty itself. So, my lord, if I may read 9 subsection 3. The central government, I'm sorry, my lords. 9.3. The central government may, by notification in the official gazette, amend the second schedule so as to enhance or reduce the rate at which royalty shall be payable in respect of any mineral, with effect from such date as may be specified in the notification, provided that the central government shall not enhance the rate of royalty in respect of any mineral more than once during any period of 3 years. So, my lord, my respectful submission is 9.3 can never be construed to be a limitation on the state's power to tax. 9.3 at best is a parliamentary limitation on the central government power to amend the schedule. Section.
Once the government changes.
So, my lord, the follow-up submission 9, by whatever extended logic, even, my lord, if for the purpose of an argument, if a lordships would momentarily consider it to be central government imposing a tax, but just momentarily for the purpose of argument alone, even then, for the purpose of entry 50, it must not impose a tax. It must go to the extent of saying that the state government will not be able to impose any other tax. So this imposition would have to be exclusive to the central government with a clear signal that the state is now limited to have any tax power under entry 50. 9, my lord, read in any manner, only, my lord, fixes royalty payable by the central government. But no part of 9 can be understood or stretched to mean that this imposes a limitation on the state government to tax.
Yes.
But my respectful submission is, if royalty is payable as a share, in respect of any mining lease area, this royalty this royalty would be equally payable to a private individual who would have mining rights. So if royalty is paid, my lord, to a private individual, the power of the state is to tax mining rights. So which means, my lord, if A is a private individual, he is leasing it to B. B is paying a royalty to A. My lord, the power under 50 is for the state to tax A for the mining rights and the money he receives as royalty, my lord, from the mining rights that he is granting. Now that power available to the state is not touched upon by 9. 9 does not say that even if royalty is payable to a private individual by the government, or it could even be, my lord, by another private individual, the amount received by the landowner, the mine owner, in terms of the land and the subterranean rights in the minerals, that can also be subjected to tax in terms of 50. This act, my lord, MMDR Act, does not in any area say that the state is precluded from imposing any tax. So 50 and the state's power to tax, my lord, is therefore not effaced or taken away, my lord, by the provisions of MMDR Act. Now, this is particularly so because your lordships have already seen section 2, which is declaration, which is to the extent hereinafter provided. The parliament declares that it is expedient in public interest that the union should take under its control the regulation of mines and development of minerals to the extent hereinafter provided. Not all the judgments which hold that this is completely occupied field, but prior to, my lord, India Cements, read this to be an occupied field, my lord, for the purpose of entry 23 and regulatory power of the state, not the taxing power of the state. So, my lord, in the context of 23, this was held to be regulatory, my lord, completely occupied area in terms of regulation. States, therefore, would not be able to make a separate regulation. My lord, therefore, India Cements, my lord, relied on the Patna judgment, my lord, and the Mysore judgment. Mysore judgment arising, my lord, in a very different context and facts, to say, my lord, that this may, my lord, in a passing sense, this may also occupy the field for the purpose of entry 50. But for the purpose of entry 50, my lord, occupied field may be a misnomer. My lord, that's my next submission. Because entry 50, exclusion would have to be by express exclusion, not by inferential occupied field theory, where a particular space in terms of even imposing a tax may be there. There could be a situation where central government, if it is otherwise enabled, could also impose tax, some tax, state government may impose some other tax. So occupied field theory possibly, my lord, in the taxation field, unless both, my lord, taxing powers are given to both entities, and one is made subject to. But if the state government has a taxing power subject to the union's power to tax,
Yes.
in that context, my lord, it can be said that the state's power is abstracted. But occupied field, my lord, is more in the context, lordships always use it in the context of 246, 254, concurrent list, my lord, regulatory space. But when the, my lord, entry 50 is so specific that there have to be a law which will have to impose a limitation, my lord, then this occupied field inferential theory possibly, my lord, may be an incorrect basis to say that the state's power is excluded. My lord, then my lord, I proceed to the next argument I want to make in this context itself. Would it be open for the state? I ask myself this question, for the union to say that any tax in the context of this enactment would be detrimental to mineral development. Because that is, my lord, the basis on which, my lord, the persons opposing the state's power are arguing that once the MMDR Act is comprehensively providing for development, even in the absence of an express limitation stipulated by law, indicating as much, if an imposition of a tax on a normative basis is going to affect the development of mines, can it be understood, my lord, that that limitation of law can also be inferential? Lord, my first submission is this will be normatively incorrect. Lord, for instance, if the state, my lord, were to impose a mineral rights tax of 1 rupee per 1,000 hectares, because the lordships are concerned with the principle, it can never be said, my lord, that 1 rupee for 1,000 hectares would affect the development.
If the tax is expropriatory, conceivably it may affect it.
Correct. My lord, then there are two remedies. One is, my lord, if the tax itself is arbitrary, expropriatory, my lord, then in a given matter, my lord, judicial review exercise can, my lord, power can be exercised by the court. Secondly, my lord, more important, in the constitutional frame of things, the parliament can step in at any point of time in terms of, my lord, the power available to it under entry 50 of list 2 and make a law forbidding or restricting the state's power to tax. My lord, like some examples, my lord, were floated yesterday, my lord, by my senior friend, that it could be for a period of 5 years, a particular mineral during the times of war, or my lord, whatever regulatory space, the parliament can always step in. So there are two levels where, my lord, correction can be done. But as a principle, as a norm, it cannot be argued that the state's power to tax today by itself, my lord, would be impeding the development of minerals. Under the MMDR Act disposition,
Yes.
my lord, the second point I want to make in response to this is, it may also possibly be in conflict with the constitutional scheme. The constitutional scheme does not think that while the central government, my lord, would have the overriding power for ensuring development and taking of minerals and mines and taking them under control wherever needed, it is still empowering the state to impose tax. But although it is conscious that sometimes this taxing power can itself impede development, so it is entering it with a caveat, my lord, that the central government can make a law to do it. So which means, my lord, the constitutional basis is state's power to tax by itself is not, my lord, militating against mineral development or mine regulation, even in controlled areas. If it is so, and if central government were to feel, central government can step in and make a law. So neither the constitutional basis, my lord, nor any normative basis can be asserted to say that the state's power to tax at whatever price, in the extreme example I gave of 1 rupee for 1,000 hectares, would automatically impede development of minerals or regulation of mines in any manner. So if it, in principle, it cannot, my lord, then it cannot be held. Lord, India Cements proceeds to say that state cannot tax at all. Lord, that principle may be incorrect. Lord, I now move on to, my lord, my submissions on entry 49, which is with regard to land. Yes, my lord, entry 49. My lord, now Mupil Nair, my lord, settles the law that productivity or produce of land, can be a reckoner for the purpose of imposing tax. In fact, in that particular case, the law was struck down because there was underclassification. A flat rate was fixed in respect of all land, regardless of productivity or actual produce or realization that is made. The Supreme Court held, that this results in underclassification. There ought to have been more rational classification, because a person who is owning vast tract of forest land, in that particular case, even at the rate of 1 rupee, was ending up paying nearly 3,000 rupees when he had virtually no income from that particular land. So, on the ground of underclassification. With regard to buildings, this principle was also upheld in the context of Rala Ram, saying that a rateable value can be fixed on the basis of the income. There is not a tax on income, but when it is assessing tax payable on land or on building, the value of the building, the productivity of the building, the potential income it may earn on a rental basis can be taken into account for the purpose of computing tax on land and buildings. In India Cements, itself, there is a tacit approval, if I may use the expression, with respect and with the Lordship's permission, that dead rent and surface rent could possibly have been used if the intention was to tax land. Now, dead rent and surface rent will have certain relationship to the mineral capacity of the land. So, if minerals and the mineral productivity or the mineral produce is to be used as a measure for the purpose of imposing a tax on land, it would synchronize with this other judgments of the Supreme Court, which says that a land's productivity and produce can be taken into account for the purpose of imposing a tax. Your Lordships have also laid down the test, that in appropriate cases, your Lordships would use the legal doctrine of colorable exercise of power. If under the guise of imposing tax on land, if it is actually resulting, or approximating to a tax on income itself fully. In Rala Ram itself, the federal court said that the legislature will have to be cautious, because if it is not cautious and the income is approximating, to the value that is going to be determined, then it can be held as colorable exercise of power for the purpose of striking down that enactment. Not on the basis that the state did not have the power, but under the guise of a power it has, it is trying to use it for some other purpose. Just another 2 or 3 minutes, I'll complete my submissions. If I may just show, this part of India Cements judgment, volume 5, page 1151. I'm sorry. Right.
Which volume is that?
1165. Yes. At 1165, if I may just invite your Lordship's kind attention to para 23. This was read in extensively, so I just want to go to the relevant part that I am focusing on. Volume 5, page 1165. The judgment starts at 1151. Paragraph 23 at 1165. After the reference to Western India Theatres versus Cantonment Board, Pune Cantonment, but after 3 lines, sentence starting with, it appears that in the instant case.
Yes.
If I may read with your Lordship's permission. It appears that in the instant case also, no tax can be levied or is leviable under the Impugned Act if no mining activities are carried on. Hence, it is manifest that it is not related to land as a unit, which is the only method of valuation of land under entry 49 of list 2, but is relatable to minerals extracted. royalty is payable on a proportion of minerals extracted. This is also the part that I would want your lordships to emphasize. It is mentioned that the Act does not use dead rent as a basis on which land is to be valued. So, my lord, two things that were held against, my lord, this cess on royalty was that land as a unit was not referred to, and it does not use dead rent, my lord, as a basis on which land can be valued.
Yes.
My lord, Mr. Dwivedi has shown your lordships that dead rent, my lord, is in the my lord, is in the nature of a minimum guarantee. It is in the alternative. Now, dead rent, my lord, would not be payable in respect of a non-mineral bearing land. Dead rent as a concept is linked to mineral bearing land. It is linked to the productivity or produce of that particular land. It is hyphenated, my lord, with that particular aspect of the land. So if dead rent can be the basis for fixing a land tax, the mineral produce not only as a measure can always be used for the purpose of fixing a tax on land for the purpose of entry 49.
Yes. Anything else, Mr. Niranjan?
But I wanted to, my lord, just invite your lordship's attention for a minute to that dissenting view of Justice Vancho in Hingir Rangpur. Lord, page 142, volume 5.
Para 53.
Yes, my lord, para 53.
What is the point that you want to make on that?
Yes, my lord. My lord, even in this case, my lord, in the dissenting opinion, his lordship, my lord, while distinguishing between what would constitute mineral rights, whether tax on minerals would also be permissible as tax on mineral rights, his lordship held that mineral rights are generally monetized in the concept of a royalty or goodwill. His lordship holds that for the purpose of taxing under entry 50, my lord, those royalty or my lord, that goodwill can be taxed. My lord, this is the last submission I wanted to make with regard to mineral rights and minerals. If I may just show this one para for your lordships. My lord, para 53 at page 172. Third sentence, this raises a question as to what are the taxes on mineral rights. Obviously, takes on mineral rights must be different from taxes on goods produced in the nature of duties of excise. If taxes on mineral rights also include taxes on minerals produced, there would be no difference between taxes on mineral rights and duties of excise under item 84 of list 1. A comparison of list 1 and 2 of the 7th schedule shows that the same tax is not put in both lists. Therefore, taxes on mineral rights must be different from the duties of excise, which are on taxes on minerals produced. The difference can be understood if one sees that before minerals are extracted and become liable to duties of excise, somebody has got to work the mines. The usual method of working them is for the owner of the mine to grant mining leases to those who have got the capital to work the mines. There should therefore be no difficulty in holding that taxes on mineral rights are taxes on the right to extract minerals and not taxes on the minerals actually extracted. Thus, tax on mineral rights would be confined, for example, to taxes on leases of mineral rights and on premium or royalty for that. So, if there is a royalty, in respect of a mineral right that is granted, that royalty can be taxed in terms of mineral rights for the purpose of entry 50. Taxes on such premium and royalty would be taxes on mineral rights, while taxes on the minerals actually extracted would be duties of excise. It is said that there may be cases where the owner himself extracts minerals and does not have any right of extraction to somebody else. And in that case, in the absence of mining lease or sublease, there would be no way of levying, right? But the learned judge goes on to hold that this can then be notionally done, comparing it with some other people. So, my lord, my respectful submission is, if mineral rights in entry 50, which enables, my lord, the state to tax, would include, my lord, that this realization that happens by way of a premium or, my lord, on royalty that is derived, which is directly linked to the mineral produce. My lord, if the mineral itself is taken into account, not for the purpose of taxing, but, my lord, for the purpose of understanding what is that mineral right which can be taxed. My lord, how can it be computed for the purpose of taxing? But in my respectful submission, my lord, the expression in the morning that was used was there is an artificial distinction that was drawn between minerals and mineral rights for the purpose of reading, my lord, the power of the state to impose a tax. But I support that argument because in my respectful submission, the royalty is a component, my lord, of the mineral produce, a share. My lord, like in the schedule, your lordships would see that it is 5%, 7.5%. In some cases, my lord, there is a fixed amount per metric ton. Relates directly to the mineral produce. So if royalty can directly relate to the mineral produce, and if royalty, my lord, can be the subject matter of a taxation for the purpose of entry 50, the taking into account of the mineral produce itself, in my respectful submission, my lord, may not be impermissible. But in fact, this is also, my lord, a case where if the tax is pegged on the mineral produce, a particular price in relation to a particular mineral, it actually, my lord, delinks it from the royalty. Not like if you lord, my lord, in that in Indian Cements case, there was 45 paise, my lord, 2 rupees 50 paise reduced to 1 rupee 25 paise for every rupee of land revenue. Land revenue included royalty. So, my lord, if the central government were to increase the royalty after 3 years, my lord, then this also goes up automatically. But if it is linked only to the mineral produce, the moment, my lord, there is an increase in the royalty, need not increase and result in increase of the tax. So, my lord, the delinking in fact shows that this is not a measure of my lord, enrichment, but more, my lord, a measure of tax augmentation.
Thank you, Mr. Reddy. Thank you.
My lord, I just had to bring to your lordship's notice, my lord, that the State Act, my lord, which is challenged, my lord, I'm appearing for the respondent here, is the other end of the spectrum. But your lordships are not going into the individual facts, my lord, just to give your lordships, my lord, the lay of the entire complexity of the issues that are before your lordships. While Jharkhand was, my lord, an act which provided that there would be a levy in relation to land as a unit at a particular price, my lord, the Andhra Act, my lord, is the other end. It says, my lord, that there is going to be a cess imposed on minerals from mineral bearing lands. But just to bring to your lordship's notice, the provision, my lord, in Andhra Act is identical or similar, my lord, to the provision in Hingir Rampur case. In Hingir Rampur, my lord, the same argument, my lord, that the petitioners who are attacking this act will make before your lordships were made. But this honorable court repelled it, my lord, stating that while it talks of mineral produce from mineral bearing lands, in effect, it is a tax on land. Mineral produce is a measure for the purpose of computing, my lord, the tax paid. So what I do, my lord, is I'll just give the 2 page numbers of the provision in Hingir Rampur case, my lord, and the AP Act, which will show that they are, my lord, almost in parity.
Thank you, Mr. Reddy.
But I'm grateful.
Thank you. Yes, Mr. Ansaria.
Finally, wait will be passed on. But tomorrow, I notice your lordship has a special bench in the
Tomorrow in the afternoon, first half of the day we are sitting. Afternoon, we have that part heard in Vedanta, which we had to complete. So we are just starting.
Next week, only a free working day. Friday is a holiday. Friday, otherwise,
Right, 8th is a holiday.
so Thursday will become miscellaneous.
So
If you can sit through whole of tomorrow without the medium.
let me just have a word with both Justice Pardiwala and Justice Mishra. So
We can start next week, Mr. Salve.
I'll just have a word with my learned brothers at the moment we rise.
I think come in the morning.
Sorry?
Turn will come in the morning.
I think, my lord,
Yes,
we
tomorrow
will,
morning your
because
turn will come.
the time which your lordship gave, my lord, we are able to
Yeah.
perhaps do it faster than that.
The afternoon also have that
The
facility
Vedanta.
of sitting, then it will be a much better run.
Let me see, I'll talk to the.
May I please, Lord? Lord, I'm appearing in item number 901.69 and 901.70.
1 second. One zero.
901.69 and 901.70 for respondent number 3, Saktinagar Area Development Authority in the state of UP. And my written submissions are in volume 1A, page 137 onwards.
Volume 1.
Page 137. Volume 1A, my lord. Volume 1A.
1 3.
137.
All right.
Lord, the section which is under challenge, it is arise out of a transfer petition filed by the SSCs, my lord. Because the main petition is pending in the High Court. Though, my lord, the same section was, my lord, upheld by the High Court, my lord, and upheld by your lordship, my lord, in Keshoram. But some petitions remain pending in the High Court and they filed a transfer petition, my lord, and your lordship issued notice and stayed the High Court proceedings. Would your lordship kindly see, my lord, volume 4, page 3864, the Act, for a minute, my lord.
Page
Page 3864
of
volume 4, where the Act is there, my lord. This is Uttar Pradesh Special Area Development Authorities Act. And it is an act to provide for the establishment of special area development authorities for the planned development of certain areas in the state of UP. And section 2B defines amenities, which includes roads, streets, water, electricity supply, street lighting, open space, etc. So the purpose is, my lord, that we are providing all these services, my lord, under the Act. And under section 6, my lord, which is at page 3866, the functions of Special Area Development Authority shall be Roman 6, apart from plan development, to execute works in connection with the supply of water, electricity, and to provide utilities and amenities such as water, etc., etc. Roman 5, my lord, to carry out building, engineering, mining operations, and other construction activity. So, my lord, for mining operations also, they have to take our permissions, my lord, and there is no challenge to the validity of section 6.5. And lordship may kindly see section 7. Special area power of the authority for the purposes of the municipal administration, the powers of a Nagar Mahapalika under the Mahapalika Act. For the purpose of taxation, have the powers of Nagar Mahapalika under the Act. And under section 8, my lord, we prepared the master plan, etc. And the charging section is, my lord, section 35, which is challenged, my lord, before the High Court, is at page 3877. I'm just one section and then I'm going to the.
Send it back to the High Court.
No,
ultimately.
Lordship is right, my lord. Just Lordship will permit me to show one section, then I'll go straight away to the entries, my lord. Subject to any limitation imposed by the Parliament by law relating to mineral development, the authorities may impose a cess on mineral rights at such rate as may be prescribed. So the Lordship would kindly note, Lord, the language of section 35(1) is in parameteria with the language of entry 50 of list 2. Now, Lordship has read entry 50 of list 2. Lordship would permit me to read it again, my lord, for a limited purpose. If your Lordship kindly see, my lord, entry 50 of list 2 says, subject, it is not, my lord, a complete fetter on the. It is an enabling entry in favor of the state to tax, and only fetter on the enabling entry of the to tax mineral rights is limitation imposed by the Parliament relating to mineral development. So there are two limitations, my lord. First is limitation on the state as may be imposed by the Parliament. It's not an absolute limitation, and only relating to mineral development, nothing else, my lord. Now, would your Lordship kindly see, my lord, it is not a power enabling, my lord, the center or this Parliament to levy any tax on mineral rights. It is a limitation on the state side, not a limitation on the Parliament's, not an enabling power in favor of the Parliament. My lord, the power of the Parliament to taxation, if the royalty is held to be taxation, my lord, it has to fall in one of the entries, my lord, under 82 to 92B of list 1. They cannot, my lord, apply a limitation power on the state to be an enabling power in favor of Parliament.
This one.
I'm so sorry. Limitation power of Parliament cannot be converted into enabling power of the Parliament, more particularly a taxing power. When the taxing power, my lord, are specifically given in entries 82 to 92B of the list 1. Now, my lord, I'm so.
Yes.
Now, my lord, entry 54 also says subject to limitation. Now, would your Lordship kindly see, my lord, it's not absolute limitation, my lord, only if the Parliament chooses to impose some limitation, my lord. Now, the MMDR Act, my lord, section 2, which my learned friend just now read, my lord, may I just read it again? It only limits to the extent, my lord, may I just read that, my lord? Section 2 of MMDR Act, which your Lordship gets in the same volume, volume 4, page 910 at 920.
Yes.
Lordship, remember.
To the extent
Now, my lord,
that-
2 says, it is hereby declared it is expedient in public interest that the union shall take under its control the regulation mines of the development of the mineral to the extent hereinafter provided. It is not, my lord, the complete field, as my lord, as sought to be argued, it's a completely occupied field. It is not that. It is only to the extent hereinafter provided. And my lord, in respect of mineral rights, because entry 50 says relating to mineral development. Now, mineral development is only in section 18 of the MMDR Act and nowhere else. Because, my lord, entry 50 further restricts the power of the Parliament relating to mineral development. And what is mineral development, my lord? The Parliament has chosen to prescribe specifically in section 18 and 18 alone. It's in volume 4, my lord, page 969. Section 18 is there.
What page?
My lord, volume 4, page 969. Section 18. Foot of the page, my lord. And it says, the heading is important, my lord, mineral development. Because that is the heading, my lord, that is the restrictive power of the parliament under NT 50. That is all which can be done by the parliament. It shall be duty of the central government to take all such steps as may be necessary for conservation and systematic development of mineral in India, for protection of environment by preventing or controlling any pollution which may be caused by prospecting or mining operations, and the central government may by notification official make rules. And in exercise of that power, my lord, the rules have been made, my lord, Mineral and Conservation Development Rules 2017. Lord, and my lord, and without prejudice, my lord, clauses 1 to Q further provides, my lord, what rules can be made. And none of them, my lord, restrict the power of the state to levy any tax. None of the rules, my lord. So restriction, if any, under entry 50 limitation power can be referred only to section 18 of the MMDR Act. And the parliament has chosen not to impose any restriction on the MMDR Act, on the state power to levy taxes on mineral rights. By saying what is mineral development?
All right. Anything else, Mr.
Now, yes, the two more aspects. My lord, there is no similar entry like entry 50, my lord, in list 1. So there is no taxing power, my lord, by parliament to levy any tax on mineral rights. But taxing power has to be specific, my lord. It cannot be, my lord. It has to be specific, express and precise, and cannot be by way of implication or interfere or inferences, my lord. In the absence of specific power to levy tax on mineral rights, if royalty is to be held as a tax, my lord, there is a good chance of challenging where is the power of the parliament to levy royalty or which is a tax. There is no power to levy tax, my lord. If that is not there, my lord, then an interpretation which may result in, my lord, and making power to be unconstitutional, lordship would interpret which is make it a constitutional. If your lordship leave it not a tax, my lord, then it is there. Then, my lord, just two more things, my lord. Lord, in Kesharam Cement, para 47 to 950, Mr. Dwivedi has read to your lordship, lord. In the federal list has to be given a restrictive meaning and not the state list, because state is already, my lord, a weaker in exercising in getting the revenue. So these are the, my lord, paragraph 47 to 50. Kesharam has said this, Mr. Sridhava has said this, that the court should be careful not to upset the delicately crafted constitutional scheme by way of interpretation and put some restrictions, my lord, by a judicial interpretation. Yes.
Yes.
Then, my lord, our next submission is that the taxing power under list 2 can be restricted by specific provision. Mr. Dwivedi has pointed out to a lordship, lord, entry 57 of list 2, which was subject to entry 35 of list 3. There is a similar provision, my lord, which was entry 54 of list 2 prior to 101st amendment. If your lordship kindly see that, my lord, which is in this book, my lord. what was there prior to, in entry 54, prior to 101st Amendment, was
Sale and purchase of goods.
tax on sale or purchase of goods other, I'm so sorry.
Yes,
If your lordship has page number 476 of the same, yes.
yes, yes.
If your lordship see the footnote, my lord, 276.
Taxes on the sale or purchase of goods
Other than newspapers subject to provisions of entry 92 capital A of list 1 and entry 92 capital A of list 1 is the tax on interstate sale. And in exercise of that power, Central Sales Tax Act was, my lord, enacted 1956. So, my lord, if the taxing power of the state was to be restricted, we have two examples, my lord. One is entry 57, Mr. Dwivedi has taken to your lordships extensively. Another is, my lord, is entry 54 till 101st Amendment Act, inserted by 56th Amendment.
Yes.
And my lord, my lord, reliance is sought to be made on the residuary entry 97, my lord, of list 1. Lord,
Covers a situation where there is no other tax.
that's right, my lord. That's why if we have a specific entry, my lord, in list 2, entry 49 and 50, my lord, so there is no question of, my lord, levying the royalty, my lord. My lord, the definitions of royalty, my lord, has been shown by Mr. Dwivedi extensively, my lord. There are one or two definitions which are not there in that, my lord, judgment of Keshoram. If your lordship kindly note, my lord.
You're putting in your
No, I have put in my note, my lord.
We'll
I'll just give the page number, my lord.
Yes.
In para 12, volume 1A, page 150. Para 12, volume 1A, page 150 of my written submission. I've given the definition, my lord, as per Hosbury, which is not there as per Black Law Dictionary, my lord, which are not there in the Keshoram. I think, my lord, the last assessment had a very clear, easier way, my lord, when the scores are scored very high by my predecessors, my lord. I'm extremely grateful to Lord. I'm extremely thankful to both my colleagues also, my lord, who assisted me, my lord, Mr. Kavya and Mr. Pawan Agarwal, my Nandinis. I'm extremely grateful to your lords.
Anybody else now? We call upon the other side.
I think, my lord, our side is.
Thank you. So, should we ask them today or you want to start? Today, in case, you've been taken by a little bit of surprise because it's just 3:30. If you want to start tomorrow morning, we are fine.
I was honestly hoping to open the matter for the reason, so I'm ready.
You're ready? All right. Otherwise, we can start tomorrow if you wanted to. We give you the option.
I can
We're about 25 minutes to go.
give your lordships a little overview of what
Yes, certainly.
really we are all about. At some point, I am going to read India Cement para by para. But explain which submission is not noted but answered. That might give some more, but nothing ultimately turns. 9 of your lordships are getting it. Your lordships also saw Mr. Justice Ranganathan's judgment. He said this royalty is a tax became the most exciting point. We should not determinative of the matter. What our reading, the genesis of this is Malad in the Patna and the Karnataka, the Mysore, is as follows. As far as entry 49 is concerned, the answer is very simple. I'm going to show your lordships. It's there in my note, but briefly, I'm going to show my lord. The genesis of it. When we talk of land, We inherited the English system through our common law. And under the English system, if you are a freeholder, tenant in fee simple, as they call it, you own everything from the tip of the sky to the core of the earth. The British, when they came up, and for large areas, and especially our richer areas were all under British ruled. Bengal, as it then was, huge Bengal area, Orissa. And all these states are very rich in minerals. They created the Geo Act 35, a mechanism. So they also realized one. This is not a question of allowing states the full measure of their taxing power. Certain taxes distort the federal balance. Not all our states are equally endowed. Orissa is rich in relative terms in mineral wealth. Bengal is rich in mineral wealth and coal. World War II days down, coal was the #1 mineral. Rajasthan, not so much now, they found oil, but knows how much more there is. Maharashtra, where we come from, was not particularly good. I don't think Kerala has any mining at all. I'm not talking about minor valuable minerals. Karnataka is rich now. So, for a holistic development of the federal India, one of the things was disparate rates of royalty. Create economic deflections. And that is why entry 50 language is sua generis. I'm going to show that. It's not tagged to development or to conservation. Unfortunately, this is settled now. The Tripsy is right from Linger Rampur to Bajnath area. So, entry 15 is sua generis. Parliament realized, or rather the framers of the Constitution realized, in fact, the framers of the Government of Act, India had realized, that you can give taxing powers to the state, but this is one particular taxing power in which you must give the federal government there against provincial governments. Now, my lord, the union government and union parliament as against the states. The power to limit the kind of tax and the quantum of tax which has been put in. First time. We have so many memories in one of these courtrooms. First time when Justice Desai said the mics had been introduced because he had
Desai had
impairment.
Hearing impairment.
And Mr. Nariman came and he picked up and read. Please use it. He says, I'm from Bombay. I don't need microphones. The court can hear what I say.
In Mumbai, sometimes you can hear the counsel in the adjoining court as well.
Yes.
That's right. Yes, sir.
Sometimes smaller courts, my lord, we ask, my lord, it's you to switch it off. Courtrooms.
Particularly now the-
We say you are this court and not for the next court also.
Limit your submissions to the point, to the law and to the courtroom.
Yes.
So, my lord, what is it that this challenge was brought as initially? And 2 or 3 submissions which have been made, my lord, shows it is necessary to, this is not, these are not issues which are res integra. The 3 kinds of balances in union and state legislations: occupied field, denudation, and repugnancy. We sometimes use them interchangeably. The 3 have very different meanings. Today I'm just giving an overview. Tomorrow, the exact citation. I'm going to show your lordship's law. Denudation is an expression which is used sometimes in conjunction with occupied field for the fasciculus of entries which have Parliament may by law declare. What's the effect of that declaration? And to what extent does it remove the content or reduce the content of this corresponding state entry? Then we have another set of entries which just say so and so subject to educational institution of higher education. State list, union also had for higher education. There the occupied field becomes more important because if it is subject to union legislation, if they have not legislated, your field is free. And the third, my lord, is the do-don't test, the repugnancy. Parliament may make a law within list 1, not even list 2. And there may be incidental encroachment into list 2. Then because of, my lord, the famous 246(1), 246(3), 246(1) says notwithstanding 2 and 3, and 246(3) says subject 1 and 2. So incidental encroachment by Parliament. To the extent of encroachment, anything inconsistent in the state laws out. That's where you apply the narrowest test, the do-don't. If I comply with one law, will I fall foul of the other? Can you say Parliament law will fail? For us, Murad, this over rigorous analysis may perhaps be unnecessary. Because we are concerned today with 2 dimensions of the matter. The interplay between 49 and 50. And secondly, what is the connotation of the limitations introduced in 50 expressing? And if these 2 questions are answered in my submission, perhaps the entire matter was resolved one way or the other. And yes, there are other side issues which will arise just to complete the full analysis, but this is one of the heart of the matter. The second is one of the overlay of our land legislation history. The British principle, the English law principle, that a holder of fee simple, full owner. So nobody, till recent time, nobody was a full owner. A holder of fee simple or a holder of fee entail. A holder of fee simple enjoyed the sky and everything which is under the surface. When in British days, the British were giving out grants, on many occasions they carved out mineral rights. And by conventional British law, your lordship knows, you had the right to every mineral except silver and gold. They were royal minerals, they were reserved for the crown. Again, everything there is by convention. That's how it is, that's how it is understood. The devolution Therefore, firstly, by way of many British grants themselves removing mineral rights because they had the pressure of World War II. You needed coal, you needed iron ore, you need to make steel. So they started removing ore. He said, yes, you shall have the run of the land, but not the mineral rights. And came in 1950, our land reform laws, which are upheld primarily as laws of acquisition of land. And in our land reform laws, inevitably it said, mineral rights will vest in the state. There are some land reform laws in which there are still some private owners. And the Act, MMDR Act, is agnostic to ownership because it also covers private owners. We have one judgment of this court called Jacob. Your lordships recognize that there are some areas, like some general lands in Kerala, for example, are still the old style because neither was the original title curtailed by the British nor were they covered by any land reform. So the old full ownership principle continues. But if you see the theater of this, it's primarily lands belonging to the government, mineral rights belonging to the government. If I do not own a mineral right, I may have 50 acres, 100 acres of vacant land where I can do farming. If you want to impose a tax on what I have, you can include the trees I grow, plants I grow. You can have on a square foot basis, you can have on some return basis. All of them are recognized as legitimate measures having nexus with the land. But if the mineral rights don't vest in me, that mineral cannot become a measure of my life. You can't then say that I'm taxing a land, the measure is the mineral. I don't own the mineral. How can it be a measure? You as well tax me on my neighbor. My measure may as well be my neighbor's land. But it has no nexus with my land. I don't have. All I have is surface rights. Now you can tax surface rights in whatever sensible measure. But you can't say, I will also tax you for things which you don't own, i.e. the mineral rights. Now this is a very important dimension which Murthy missed when looking at 49. And the second problem it missed, and it is now not accepted, the special excludes the general, even in constitutional lists. If land includes, all my friends have given the definition, if land includes everything from the core of the earth to the tip of the sky, why did we then need a separate tax on mineral rights? Just had 49. If mineral rights is carved out from the field of tax legislation, placed under a separate entry, and which entry is limited, to what extent is a separate matter. You then cannot say, maybe so, but I still have my 49. There's no limitation. Then you're distorting the scheme of the constitution.
Provided it is a tax on mineral rights.
That's right.
So if it's a tax on mineral rights, then the legislative field is covered by, not by entry 49, but by entry 50.
My lord, if I am...
But if mineral rights really, it constitutes a measure of the tax as distinct from the taxing entry.
That's what I'm saying.
Entry 49.
Today I own a piece of land. I own a piece of land, I own 50 acres of land where I do farming. There may be a seam of iron ore under there. I can't touch it. A doesn't belong to me. Because under Indian jurisprudence, that belongs to the state. And B, I can't touch it unless I go under the MMDR Act, apply, get a permission. And that too not as owner. I will get a lease in my very land to work a mine which rests in that state. How can that mineral wealth be a part of my annual value? Can't be. I have no right to it. I have as little right to that mineral as I have to my neighbor's land. Can you say the annual value of your neighbor's land will be your annual value? Your lordship will strike it down for the asking thing. This is not about annual value. Must have nexus. But not the Raliaram downwards cases. We did all those cases, Malot, back in the day, Raliaram, Bodu Paidana, Raleigh, where in a house or a building, income tax could tax the income from that building. That is the tax on income. And the states could tax through the municipal bodies the building itself. Now, in one day, in that very building, if I'm the owner, and we are not unlike England, we have had tax on the occupier, not on the tenant. So, if you want to tax my building, you can tax it on square foot basis, or you can tax it on applying a value, or you can say its capacity to yield income becomes a measure. That's the Raliaram principle. The rent I may receive is not the measure. The rent I receive is a method of valuing the capacity of that building. And that is the relevant measure for that tax on the building. I own everything. I own the right to let that building out. So even if it is vacant, it means nothing because I have that right. I may actually give it out to somebody who may be paying me much less than market rate, or I may give it out to somebody who's paying me much more than market. But the inherent capacity, we have all these cases from Daulat Rai, Diwan Rao, etc., which have said you have to go by the capacity of the hereditament to yield an income. Perfectly sensible. But you cannot apply that. Suppose, Malad, in a house tax or a tax on land and building, somebody said, and by the way, where your building is, like, we believe there are some seams of iron ore. We will add that also. Can't. Because I have no right to that iron ore. It's there, but if somebody has to buy my land, then go to the government and get mining permission, get a lease, pay the state because this belongs to the state. So, Malad, this is, we'll have to put all this together.
Sorry, just one, if we take the whole of tomorrow, you'll be wrapping up tomorrow? You'll be able to wrap up
Maybe
tomorrow?
because I'm the opening, there's a lot of cases
Right.
which have not been shown. Certainly by Tuesday afternoon.
By Tuesday, so. Ask her anything.
And the attorney is there, my learning friend, Mr. Mehta is there.
But my estimate, sorry. You're saying something?
That we have.
I'm telling you.
Tarve, what we'll do is we'll take a break tomorrow in the afternoon. So we'll hear this matter in the first half.
Till one.
Till 1 o'clock. And because if you were likely to finish, then we would have seen. But what will happen is, if I have to now reconfigure all the benches, the other benches will again have to be in the evening.
Very realistically, but if you are looking at the next week, 2 days, all our sides getting over doesn't look very likely.
But you see, they had also handed down an assessment of 4 days, which we came down to about a day and a half.
Quite frankly, may I tell my concern is on the timing issue. My learned friends have, in one sense, come with an advantage saying, Kesar, I'm held this enough here. If you start reading India Cements, there's much you can pick on it. Let's be candid. One sentence, somebody says doesn't match the other sentence, etc., etc. The real case is not even opened before you.
You have to argue it really from
Really?
a matter of first impression.
They have to take from Kesar, we have to argue from the beginning. That's
Okay.
without being
So tomorrow we'll assemble at 10.
For sure.
We'll assemble at 10:30 tomorrow morning.
And union sandwich between these two will have to have a certain angle.
We noticed that you are a little closer to this side than you.
Yes, yes, they're completely that side, my lord. This time union.
All right, tomorrow
Very
morning, 10:30.